Good morning. This morning we're going to cover the hearsay definition, Article 801, sections A through C. I'm going to share my screen with you. I want to share a PowerPoint presentation for this for this discussion. Okay. As I said, we will discuss hearsay definition. We move into a new area today, very vast area, very lengthy area. It would take us about maybe 3 weeks, maybe even a month to cover hearsay and all of its exceptions and all of the rules that deal with hearsay. But we have to start with what is hearsay, the definition of hearsay. And what I want to do is, as I said, share my screen, and we're going to go through a PowerPoint presentation just to deal with those primary or those initial uh, statements or initial concepts that we must understand to understand why hearsay is not acceptable, why it's not admissible at court. But it's really interesting when we say that hearsay is not admissible at court because we have so many non-hearsay rules and we have so many exceptions to the hearsay rule that it seems that the general rule that hearsay is inadmissible becomes the exception rather than the rule. So let's move on. The first thing I want to do is I want to look at the definition and the rationale for hearsay, the definition for hearsay and the rationale for hearsay. Hearsay, a statement other than one made by the declarant while testifying at the hearing or at trial, often to prove the truth of the matter asserted therein. Now, if you talk to any attorney, and you can stop any attorney that's worth his salt, you can stop him on the streets today. You can ask him what is hearsay. And let me tell you the definition that he's going to give you. It's very similar to this definition, but it's shorthanded. He's going to tell you hearsay is an out-of-court statement offered to prove the truth of the matter asserted therein. Now, if you look at the definition that we have here, it's broken down and says that hearsay is a statement other than a statement made by the declarant while testifying at the trial or hearing, and it's often to prove the truth of the matter asserted. The shorthand definition is good. It gives everything and give all of the essential elements. An out-of-court statement often to prove the truth of the matter asserted. Now let's see what this exactly what this means. I have an example here. And what I want to do before I go into the definition for hearsay, let's look at the rationale for hearsay. And why is hearsay not acceptable, hearsay testimony not acceptable at court? If you remember when we started the semester, we looked at Article 102. Article 102 says that the purpose of the evidence articles, the evidence rules, is to make certain that there's a fair administration of justice for the purpose of attaining truth. We want the jury, the trier of fact, to hear all the information that's necessary for them to make a fair determination. We want also them to hear the information that's going to actually end in a fair result for both parties, hopefully a fair result for both parties. And so therefore, some information, even though it may be hearsay, even though it may be relevant, some testimony, some evidence, even though it may be relevant, it is going to be excluded. It's going to be excluded because it is not, because it doesn't meet the requirement for a fair administration of justice for the purpose of proving, for the purposes of getting to the truth. It is not necessary for the expedience of the trial and other reasons that we have the hearsay rules. Now let's take a look at our definition. Assume that X asks Y if he knows of any good evidence proof. Y tells X that sum and substance by Gifford is the best evidence proof that can be found. After talking to Y, X is approached by girl in the atrium. Girl asks X, do you know of any good evidence proof? X tells girls, I just talked to Y, had the same question, and Y told me that sum and substance by Gifford is the best evidence proof that can be found. If the question at trial is whether sum and substance is the best evidence proof, is girl's statement about what X told her hearsay? Is she the best person to testify to the statement made by X? Why? Let's take a look at it. Here we have X asking Y. Y tells X. X tells girl. Now we want girl to testify to what X told her. Now the question is, Is the statement, is she the best person to testify to the statement? Should we allow that statement in? There are many problems with this statement. Hearsay is not admissible because the reliability of the out-of-court statement depends on the credibility of the declarant, the person who made the statement at the time that the statement was made. In order for the statement, the best person to testify to that statement, I should say, is going to be the person who made that statement. But there still is a question, there still is a problem with it, because the credibility of that statement, depends upon the credibility of the person at the time that they made the statement. And we can't test that person at the time that they made the statement once we get to the trial, that the statement has been made. And now we want to introduce that statement at the trial. And there's certain things, several things that we don't know that will affect whether we should allow that statement into the trial or into the trial procedure or not. Let's take a look at those things that will affect whether we should allow that statement into the trial procedure. First of all, the perception. Y told X that sum and substance is the best evidence proof that can be found. And it's based upon Y's perception of sum and substance. Has he read sum and substance? Has he read all the material? We don't know what's the basis of his conclusion. Has he compared it to other proof? We don't know what his perception and how he reached that particular conclusion. And therefore, we are admitting something that Y has said out of court through girl, and we want to admit it through girl. And so we cannot test Y's perception. And Y's perception of sum and proof at the time, sum and substance at the time that he made the statement is important. It is important. The credibility of the statement depends upon his credibility at the time that the statement was made. But Y's perception, we don't know what the Y's perception was at the time that it was made. The next fault, or the next failure, is memory. Has Y forgotten what he read? Has Y forgotten what he read in sum and substance? Is the memory in reference to sum and substance accurate? And does it have been accurate in order to make this statement? And we can't test that. And the credibility of that statement depends upon his memory. And we can't test his memory. Clarity. Did he mean that it was the best, one of the best? What does it mean when he says the best? Is it best overall? Is it best in certain areas? Why sincerity? Is why lying? Does he have motive? Does he want to lead them to Gibbers because there's a better poop that he's going to read? Why is sincerity? None of these things can be cross-examined or tested at the trial. And all of these things are important. The credibility of that statement, it depends upon these particular things in reference to why. And we can't test them at trial. Because the statement was made outside of a trial. At trial, the right to cross-examine the declarant about the statement is important. And all a hearsay statement. Hearsay. And all a written statement. Definition of hearsay. We said that hearsay is an out-of-court statement. Hearsay is an out-of-court statement. Now the question becomes, what is a statement? We've just given you the reasons why it is inadmissible. Inadmissible because the credibility of the statement depends upon the credibility of the person at the time that the statement is made. And we can't test several things. We don't have the right to cross-examine several things, and therefore we should not admit it into evidence. And all statement or a statement as defined by 801A is an all a written assertion or a nonverbal conduct of a person that is intended to be assertion, that is, it's intended to communicate something. It's an all or nonverbal conduct of a person that's intended to be assertion that is intended to communicate something. We have no problem if it's all. We have no problem whether it's written. We know it's a statement, right? We have a piece of paper that's something that's written and we want to introduce it into court. Out of court statement, right? Someone says something out of court, right? Says something out of court statement, right? We know the statement. The question becomes, or the issue arises when we talk about a nonverbal conduct. a nonverbal conduct. Nonverbal conduct that's intended to be an assertion is going to be considered a statement. And it's an assertion when it's intended to communicate something. Let's take a look at look at a couple of examples. A question at trial is, was it 12:15 when an incident happened at the law center? A student in class asked Jones, what time is it? Jones always ends his class at 12:15. Jones looks at his watch, ends his lecture, and walks out of the class. Are Jones' actions hearsay if proved that it was about 12:15? If offered to prove that it was about 12:15? Question at the trial is whether it was 12:15. Jones is always prompt. He ends his class at 12:15. Student asks in the class, what time is it, Prof? What time is it? Prof looks at his watch. He ends his lecture and he walks out of class. Now, statement, we don't have an oral statement, right? We have no written statement, right? But we have conduct. Is that conduct intended to assert? Is it intended to communicate something? Is it intended to communicate something? What do you think? You're correct. You're correct. Here, that nonverbal conduct is an assertion. The nonverbal conduct is an assertion. Why? The question at trial is whether it's 12:15, whether it was 12:15 when the incident happened at the law center. And they want to introduce the statement from the student. They want to introduce Jones' conduct. Jones is responding to a statement that's made. If the conduct is a response to a question, if the conduct is response to something, then it's intended to communicate. When the student asks Jones, what time is it? Jones always ends his class at 12:15. Jones wants to signal when he closes his book, when he ends his lecture, and Jones walks out of class. Jones is signaling what? End of class. Jones is signaling what? 12:15. And so it is Jones' intent to tell the student, it's 12:15, class is over. It's 12:15. And so Jones is responding. Jones' conduct is responding to something. It's responding to the question that's asked by the student. Is responding to the question that's asked by the student. Let me give you another example. Another simple example. Person walks up to Jones and asks Jones, are you the best evidence professor in the state of Louisiana? Jones smiled and Jones says, nonverbal conduct? Yes. Statement? Yes, you got it. Why? It's meant to communicate what? Meant to communicate the truth. Jones is the best evidence professor in the state of Louisiana, right? Meant to indicate the truth. Let's move on to another example. The question at trial is whether it was raining on the day that X slipped and fell outside of a barber shop. To show that it was raining, X wants to introduce that when Barber A was leaving the barber shop, he grabbed his rain boots and umbrella. Hearsay? First thing we have to make a determination. If we're going to make a determination, if it's hearsay, whether it was a statement, And here, we don't have an oral statement. We don't have a written statement. They want to introduce the barber's actions, his nonverbal conduct, to show that it was raining on that particular day. The question at the trial is whether it was raining on the day that X slipped and fell outside of the barber shop. And so what do they want to introduce? That when Barber was leaving the barber shop, he grabbed his rain boots, he grabbed his raincoat, he grabbed his umbrella, and he walked out. Now, is that nonverbal action? Is that nonverbal action? Did he intend to communicate something? Was it intended to be an assertion? That is, that it was raining on that particular day. You got it again. No, it is not a statement. It is not a statement. That nonverbal conduct is not in response to anything. It's not in response to whether no one asked whether it was raining. It's not in response to of weather report or anything. It's not in response. The declarant does not mean to communicate anything. In order to determine whether nonverbal conduct is going to be an assertion, you look to the declarant. Does the declarant intend to communicate? Does it intend to assert something? And here is no communication intent here. He just gets his galoshes, he gets his raincoats, he gets his umbrella, he gets his rain hat, and he walks out of the door. He's not communicating anything to anyone, but he knows that it's raining. Last one, and this one we just did. Bystander testifies that he saw business partner nod affirmatively when he was asked if creditor regularly padded customers' bills. The action is offered to show that creditor illegally padded bills. Is it hearsay? Yeah, it's hearsay, right? Why did he do? The question was asked. Y'all pad those bills? Yeah, we do some. Yeah. He is responding. The declarant is communicating by nodding yes. His intent is to communicate something. We pad bills. The truth of the matter asserted. Now, this is where the issue really rises. This is where the issue really arises, when we have to determine whether the statement is offered to prove the truth of the matter asserted therein. Whether the statement is offered to prove the truth of the matter asserted therein. Let's take a look and see what that means. Utterance may be offered for a variety of reasons not entailing their truth. When they are, there is no need to assess the credibility of the declarant, but the value of utterance does not depend on whether it is true. Oh, wow. What does that mean? Okay. Now, the truth of the matter, first we need to define that. What is the truth of the matter of the statement? The truth of the matter is the content of the statement. The content of the statement. Y and X went to dinner. After they finished their dinner, Y says, my stomach is hurting. I've never felt this way in my life. My stomach's hurting really badly. And my stomach started hurting after I ate those jacked up oysters. Now, the question becomes, in order to determine whether it's the truth of the matter asserted, the first thing you have to make the determination of is what is the content of the statement. My stomach is hurting, and my stomach started hurting after I ate the jack up oysters. That's going to be a suit, right? We're going to sue the restaurant for food poisoning, what they call it, botulization or something. I can't remember the word, but we're going to sue them for food poisoning. We're going to sue them because their food caused us to be sick, that there was an injury as a result of us eating at that restaurant. Now, want to introduce that statement. My stomach is hurting. I started hurting after I ate the jacked up oysters. Is it offered to prove the truth of the matter asserted? The truth of the statement is the content of the statement. The content of the statement. The content of the statement is what? My stomach is hurting. It has never hurt like this before, and it only started hurting after I ate the jacked up oysters. That's the content of the statement. If the statement has been made to prove the content, is being offered to prove the truth of the matter asserted. If the statement is offered to prove the content of the statement, it's been offered to prove the truth of the matter asserted. What is the proponent of the statement trying to prove? That's the first thing you have to make a determination when you're dealing with the truth of the matter asserted. And so you have to make a determination. Why does this person want to introduce the statement? Remember what we told you at the last class period, that what you have to do, you have to always remember, where are you in the trial? Who's offering what? Who's offering it? And why do they want to offer it? Who's offering what? Why? So you have to make it determined. Here we have a statement. Why does the proponent wants to offer that statement? Why does he wants to offer that statement? What is he trying to prove with that particular statement? Is the content? What is the content or substance of the statement? My stomach hurt. It has never hurt like this before. And it only started hurting after I ate the jacked up oysters. Does the proponent want the witness to testify to the content of out-of-court statement? If the issue, or if he wants him to testify to the content of the out-of-court statement, is to the truth of the matter asserted. Is a witness testifying to information obtained through a personal knowledge or information contained in out-of-court statement? Let's take a look to see what that means. Now, there are several reasons. The first statement goes back. There are several reasons for which that out-of-court statement can be admitted other than the truth of the matter. One reason may have other legal significance. Before I do this, I want to skip over to another slide, and then I'm going to come back to that slide. Let's skip over to this slide. One reason is, as we said, it may have other legal significance, but there are four other broad reasons for which the court have accepted statements to be not made for the truth of the matter asserted, because they have other grounds for admissions other than the truth of the matter asserted. Again, courts have found that a proposed statement is not hearsay if there are other grounds for its admission other than the truth of the matter asserted. And there are four broad bases, broad concepts that probably will cover them all, but there are several, but these are the four major that I would assert that you should know. The first one is that the statement was made. If the statement is offered, it's a proponent of a statement. Remember, we have to, this is defined, we have to make a determination. Why does he want to offer the statement? Let's look at the statement. Why would he want to offer the statement? If the proponent is only offering the statement for the purpose of showing that the statement was made, it is not offered for the truth of the matter asserted. Therefore, it will not be hearsay. If the proponent is offering the statement only for the purpose of showing that the statement was made, it has not been offered for the truth of the matter asserted. Therefore, it will not be hearsay. Let's look at an example to see how this works when we talk about it being offered for the statement that the statement was made and not for the truth of the matter asserted. A prankster yells fire in a crowded theater and is indicted for inciting a riot. The prankster's statement is offered at trial not to show that there was a fire in the theater, but to show that the prankster made the statement. It's not offered to show, and we don't want to offer to show that there's a fire in the theater. What's the content of the statement? Go back. Why is he offering it? What's the content of the statement? What's the content of the statement? Content of the statement is fire, fire. There's a fire in the theater. Now, are we offering it to show that there was a fire? No. We don't want to offer it. The proponent state doesn't want to offer it to show that there was a fire in the theater. The state wants to offer it for the purpose of showing that the statement was made in order to prove that the person incited a riot. They want to offer it for the purpose of showing that the statement was made. He made the statement. It's not been offered for the truth of the matter asserted. And so the other ground, other than the truth of the matter asserted, is that this statement was made. Another is words or acts that have legal significance. Many times words or acts have other legal significance other than the truth of the matter asserted. And if they have other legal significance other than the truth of the matter asserted, then it's not going to be hearsay because it's offered for other legal significant reasons. It's offered for other legal significant reasons and not for the truth of the matter asserted, therefore, not hearsay. In a contract dispute, plaintiff wants to introduce statement made by defendant that accepts plaintiff offer to buy Starbright, a prize stallion. The statement has legal significance to show that there was an oral contract to sell the horse to plaintiff. They have a contract dispute. Nothing is written. There's an oral contract, an oral agreement, a handshake agreement that was made. I offer to buy Starbright from you for $500,000. Defendant says, deal. You got a deal. Somebody else comes along and says, look, I'll offer to buy Starbright from you for $750,000. Now he wants to get out of the deal with the plaintiff because he's got a better offer. But plaintiff says, we had an agreement, a handshake oral agreement. And plaintiff wants to introduce into the case the fact that we had this oral agreement. And so he wanted to introduce the statement that I offer to buy Starbright from you. And the defendant actually accepted the offer. He says, yes, I will sell Starbright to you for $500,000. Out of court statement? Yes. Is it offered to prove the truth of the matter asserted? Is it offered to prove that offered to buy Starbright from you for $500,000? It has other legal significance. It has other legal significance to prove an oil contract. What do you need for a contract? You need an offer and an agreement. Here, he wants to prove the offer. He wants to prove the offer, a part of a legal concept that's necessary in order to show that there was a contract. Therefore, he's not offering it for the purpose of saying that I want to offer to buy, but it to show a legal concept. And therefore, courts have said that it's not offered to prove the truth of the matter asserted, but it has other legal significant reasons that um, that the statement is being offered. Therefore, it is not hearsay. Another one, the state of mind of the declarant hearer. The state of mind of the declarant hearer. Let's assume that defendant is charged with second-degree murder. Defendant wants to introduce into evidence. Defendant said it wasn't second-degree murder, that is manslaughter. And he wants to introduce into evidence statement that was made to him by his best friend. And best friend tells him before the murder, immediately before the murder, that wife is at the no-tell motel again for the third time this week with victim. Defendant murders victim. Defendant murders victim. Is a statement hearsay? Defendant wants to introduce that statement. Wife is at no-tell motel for the third time this week with victim. He is claiming it's manslaughter. That statement has other legal significance to show his state of mind at the time of the killing. And the state of mind at the time of the killing is important for his manslaughter, to have it mitigated to manslaughter, because he wants to show that there was sudden passion or heat of blood. And therefore, the statement has other legal significance. It's part of what the manslaughter requires. It's an element of manslaughter that I have to show heat of blood or sudden passion. Another one, the listener's knowledge or awareness of certain circumstances. The listener's knowledge or awareness of certain circumstances. Let's assume that operation takes place. Operations takes place, and a sponge is left in after the operation, and the person has severe reaction to the sponge being left into his body after the operation, and now he wants to sue the doctor. The person or the plaintiff wants to introduce into evidence that the nurse told doctor, Doc, I've counted only 9 sponges that we've taken out, and we used 10. Is that statement going to be offered for the truth of the matter asserted? This is going to be hearsay. Doc, we only have 9. We've only retrieved 9 sponges, but we had 10. We used 10. Is it offered to show that there's 1 that's left? No. The statement is being offered to show the knowledge of the doc, that he acknowledged. He acknowledged that there were only 9 sponges that were retrieved and that 10 were used. It's not been offered to show the truth of the matter asserted, that we had 9 something. It's been offered to show knowledge and awareness that a sponge is absent. Okay, let's go back to and take a look at some examples. The defendant drives through a stop sign and strikes B, who's riding his bicycle. The defendant rushes over to B and states, I'm sorry, I did not see the stop sign. His testimony that at trial as to what the defendant said to him, hearsay. It's B's testimony at trial as to what D said to him, hearsay. Drives through a stop sign, he strikes B, who's riding his bicycle. He rushes over, he said, I'm sorry, I didn't see the stop sign. Is it hearsay? Is it offered to prove the truth of the matter asserted? Statement, yes. Oral statement. Out of court, yes. Offered to prove the truth of the matter asserted? You got it. Yes. He's offering to prove that he did not see the stop sign. He's offering to prove, I'm sorry, I did not see the stop sign. Now, don't worry about it. The statement is going to be admissible. The statement is going to be admissible, but it is being offered to prove the truth of the matter asserted. But that statement will be admissible, and we'll get to that a little later. We're not talking about admissibility now. We're only dealing with the definition of hearsay. Do not be concerned at this particular point whether the statement is admissible. As I said, there's several exceptions to hearsay rule. There's some non-statutory hearsay rules that will apply that let a statement in, even though it may be offered for the truth of the matter asserted. So don't be worried about the admissibility of it now. We're only trying to determine whether it meets the definition of hearsay. In a defamation suit, P wants to offer a statement that D called him a dirty, rotten scoundrel at the party honoring the president of the company. Hearsay? You got it. It is not hearsay. It's not been offered to prove that he was a dirty, rotten scoundrel, but it's been offered to prove as a part of his defamation suit. It's been offered to prove that he did call him, he did defame him. It's not offered to prove that he's a dirty, rotten scoundrel, which is the content of the statement. We look at the content of the statement. What is the content of the statement? You're a dirty, rotten scoundrel. Is he offering it for the purposes? And who wants to offer it here? Who wants to offer it? P wants to offer it. Plaintiff wants to offer it against the defendant who he sued for defamation. Now, he wants to offer it for the purpose of showing that he called me a dirty, rotten scoundrel that defamed me. Content of the statement is dirty, rotten scoundrel. Not offered to show that dirty, rotten scoundrel. Not offered to show that he was dirty, rotten scoundrel, but that the statement was made. That the statement was made. It's been offered to show that the statement was made, and therefore is not offered for the truth of the matter asserted. Offered to prove that D shot V. A statement from D's wife that offered to prove that D shot V. A statement from W that he saw D shoot V. Hearsay? You got it again. It is hearsay. Out of court statement offered to prove the truth of the matter asserted. What's the truth of the statement? What's the proof of the statement? The truth of the statement. D, I saw D shoot V. Witness, I saw D shoot V. Out of court statement, I saw defendant shoot the victim. Offered to prove the truth of the statement? Yes, that's why they offered it, for the purpose of saying that he saw defendant shoot V. Therefore, it is hearsay. Offered to prove that it's been offered to prove that D shot V. Okay. Offered to prove that lover gave girl an engagement ring as a gift. Lover gave girl an engagement ring as a gift. A written card that lover gave to girl when he handed her the ring. The card states, our love will last forever. Our love will last forever. Now, the content of the statement. Statement, yes, written. Content, our love will last forever. It's been offered to prove that lover gave the engagement ring to her as a gift. Offered to prove the truth of the matter asserted? The truth of the content of statement, our love lasts? No, it's not being offered to prove the truth of the matter asserted. The truth of the statement is that our love will last forever. The content of the statement is that our love will last forever. She's offering to prove that lover gave engagement ring as a gift. Lover gave engagement ring as a gift. Is it hearsay? No, it's not hearsay. It's not being offered to prove that our love lasts forever, but that engagement ring as a gift. Prankster is charged with inciting a riot. We did that. We have done that one. Now, what I'd like for you to do, I will I am going to send to you several statements. As a matter of fact, there are 10 statements that I will send to you in an email once I've completed this. Once I've completed this this presentation is ended. You must answer those 10 questions. You must answer those 10 questions. They're only by saying, number one, is it hearsay? Are they hearsay? And number two, you must also give me a very short, no more than 5-word explanation as to whether it's hearsay or not. No more than 5 words, no more than 5 words for each question. If you fail to do so, you receive a 5-point deduction on your final grade for the course, and you'll be marked absent for this particular class. And so I'm going to stop my share. We're going to end this presentation,